feel that is a matter of EOG and KTT and it's a different upstate for the Health Department?
Yes, Mr. Butler.
Thank you, my Lord. I had just begun yesterday addressing ground 2, meaning of the policy. And we had discussed whether this was an issue of fact or an issue of law, which would go to the questions of the threshold for reviewing Mr. Justice Linden's decision and whether PK Garner was binding authority on the meaning of the previous guidance. That's where I think we had got to. I propose, if I may, to structure my submissions on this issue in 3 parts. First, what was the context in which version 2 of the policy was made? Second, what does version 2 of the policy say? And third, what has the Secretary of State said about version 2 of the policy since it was made?
And when was it made?
It was made...
2018?
It was 2018. Can I just get the precise date? It was the 10th of September 2018.
And it applies to your case, formally,
Yes.
but not to EOG. Is that right?
Yes, I think that's right.
EOG was before?
I'm afraid I can't speak to EOG's facts.
It wouldn't apply to someone in EOG's position because it's so well.
Well,
Her point is it should, yes, or something like it should, yes.
Yes.
Quite right.
But I mean, no, I would like to know that. Which is the policy that was or would have been applied to her case, to EOG?
Yes.
Just for the sake of completeness, because I need to have that in mind when you're giving me background to version 2, what happened after version 2 by reference, no doubt, to PK Garner and all the other cases that happened. We need to see that in the context of which policy was enforced. So if we can find that out pronto, that would be great.
Quite so. We will do so. It may be that I leave it to Ms. Weston, if I may.
Yes, fine.
We'll find out.
Okay.
So if I could begin with the context in which version 2 of the policy was made. The predecessor policies were considered in 3 cases, Tamawan, PK Garner and MN.
In that order?
In that order.
Tamawan, PK Garner and...
MN.
And MN is Mr. Justice Murray?
No, that's JP.
Oh,
JP considered this version of the policy.
Who is MN?
MN was
MN
by the Court
is
of Appeal.
this judgment of the court delivered by Underhill LJ.
The Vice President.
Yes.
And a Tamawan was...
Tamawan was a divisional court case. Aikens, Lord Justice Aikens.
And PK Garner was Higginbottom LJ.
Yes. But I will, if I may, show the court those authorities.
Yeah.
It was accepted in those 3 cases that the previous policies did require decision makers to comply with Article 14 PCAT. That's one of the points that I want to show the court through those authorities. But while I'm showing you those authorities...
Can I just hear that? It was accepted in all 3 cases that the previous policies did require.
It was accepted in some, so I should be clear, and I will be clear when I take you to the authorities. It was accepted in all 3 cases that the policies were intended to give effect to ECAT generally. It was accepted in PK Garner that the policies in that case were intended to give effect to Article 14 specifically.
Right, well that's no longer in contention.
That's not in contention. But But while I'm showing the court those authorities, I also want to identify another point that is relevant to the second issue in the appeal, and that's the one which I trailed yesterday. I said yesterday that I accepted that where a policy sets out requirements that are different from ECAT, then it may be possible to argue that this represents a deliberate departure from the requirements of ECAT. So that on a proper construction of the policy, it doesn't require full compliance with the relevant provisions of ECAT. That's a proper argument. The other point I made yesterday was that it's also perfectly possible for a policy to require compliance with ECAT, but then to erroneously misstate what ECAT requires. And it's that point that I want to illustrate by reference to Atamawan, PK Garner, and then later on JP. And in that situation, where the policy requires compliance with ECAT, but then misstates its the requirements of ECAT, then the question arises that was posed by my Lord the Vice President yesterday: should the court strike down the offending passages, which is what happened in PK Garner and JP, or should it read them in a way that is compatible with or subject to the overarching policy intention? And that's what Mr. Justice Linden did. Either approach works for my case.
Sorry, when you say works for your case, do you mean you would be content with either? Why doesn't it matter to you which? It's simply because it's now all of historical interest to your client. Is that's the reason why?
Well, that is the reason why.
Yeah, because they do have different consequences.
Yeah, well,
in the short term.
They ultimately have the same consequences for my client, in that if a policy is legally flawed because of an inconsistency between the overarching policy intention and then the way it's given effect, what one gets by way of relief is a declaration, possibly a quashing order in respect of the offending parts of the policy, but ipso facto, a decision that is taken pursuant to that flawed policy and applies those flaws is itself legally flawed.
Yes, I see. Yeah.
And one sees that in PK Garner and JP, where the court says, well, the court grants a declaration that the policy is legally flawed, and then on that basis and on that basis alone,
you're
says,
quite right.
says the application of that policy to the individual decision in those two cases was itself flawed, and grants a declaration to that effect. So if I could begin then with, having trailed the point, turn to Atamawan. That's in the 4th volume of Authorities, tab 42, page 1570. And if the court would please look at page 1580, one can see at paragraph 38 the guidance that was issue in that case. That is the guidance for the competent authorities issued in 2010. If it's not,
am I right in thinking that that's not the guidance as such? It's not an equivalent to the guidance if it were concerned, in the sense it wasn't only or even mainly about discretionary leave. Is that right?
correct.
It's the overall NRM guidance.
Yes,
Is that it?
it is. And could I show the court what that guidance said? I'm sorry to jump between bundles, but I think I need to do so. It's volume 1 of the materials bundles, tab 3, page 77. So there one sees the heading, and if we could please look at page 109. The umbrella heading for this section is conclusive decision outcomes. And then on 109, there is a heading halfway down the page, victims who are assisting with police inquiries from UK. And one sees in the first paragraph, due to our obligations under the Council of Europe Convention on Action Against Trafficking in Human Beings, we have agreed that in those instances where a victim has agreed to cooperate with the police, we will grant them a period of 12 months discretionary leave specifically to assist with police inquiries. And then overleaf on page 110, there is a heading, second heading, victims who qualify for another form of leave, which provides victims whose stay in the UK may be necessary due to their personal circumstances, such as family and health needs, should be considered for discretionary leave in line with existing policy. So 14.1a ECAT issues were outsourced to another policy which wasn't before the court in Tamuan. And then at the bottom of page 110,
Just so I can spell that out, though, I think I'm right. Tell me if I'm not. That there was at around that time a formal guidance called discretionary leave, which basically looked at a whole number of circumstances in which people might be granted leave outside the rules. A classic example being people who ought to be returned but couldn't be because of conditions in their country or whatever it might be. And it had other examples too, maybe compassionate of one sort or another. And this was, as it were, fed into that guidance. Is that, have I got that right?
that's as we understand it.
Thank you.
And then finally, sorry, not finally, bottom of page 110, we would expect victims who don't have a right to remain in the UK to then return home, giving due regard to Article 16.2 of the Convention, which we looked at yesterday. And then finally, page 111, there is a heading, Appeals Against a Decision, the Council of Europe Convention, ECAT, upon which our victim care arrangements are based, doesn't require parties to have an appeal process. So that is what the guidance before the divisional court in Tamuan said about ECAT. That's all I want to show you on the guidance document.
Thank you very much. Do we have a date for that?
The date is given as 2010 in the divisional court's judgment. It's given in the index to the materials bundle as the 13th of October 2010. If If I may turn back to Atamawan, page 1589. We see paragraph 69, third line, the guidance purports to set out this policy in a manner consistent with the provisions of the Convention Against Trafficking. So just pausing there and leaving the temptation to read on for a moment. The first point I take is the factual one, that at this time, the Secretary of State's guidance did purport to comply with ECAT. And then the second point I wanted to make is the concession by Sir James Eadie, which one sees in the following sentences of paragraph 69, that to the extent the guidance didn't comply with ECAT, there would be a justiciable error in the guidance and in any decision to which it applied.
When he says as already noted, can you just give us the reference for that?
Page 1586, paragraph 55, and if I could ask the court please to look at that. Paragraph 55, line 4. He, Mr. Eadie, accepted, at least in this court, that although CAT hadn't been transposed into domestic law by legislation, and so didn't have direct effect insofar as the guidance purported to give effect to the terms of the CAT and failed to do so, that would, insofar as the guidance purported to give effect to the terms of the CAT and failed to do so, that would be a justiciable error of law. He also accepted that to the extent that the NRM decision was itself based on the terms of the guidance, if they were in turn based on an erroneous interpretation of the CAT, then the NRM decision could be challenged by judicial review because that decision would then have been based on a misdirection as to the legal basis for the relevant wording of the guidance, the point I made a few moments ago. In that case, the divisional court held that the guidance was inconsistent, and it was inconsistent with Article 4 of ECAT, in that it excluded victims of historic trafficking. If you need the encapsulation of that, it's paragraph 70. Page 1589. In my view, Lord Justice Aikins, giving the judgment, these passages in the guidance are based on a misinterpretation of Articles 4, 10.2 and 13.1 of the CAT. And so the divisional court didn't conclude that the narrowing of Articles 4, 10 and 13 in the guidance represented an intention to depart from ECAT, but rather that it was a misinterpretation of ECAT which the policy intended to give effect to. just while we're in Atamawan, I should probably show the court page 1592, paragraph 79, where there is a passing reference to Article 14 of ECAT. That's all I wanted to show the court on Atamawan. If I could then please ask the court to look at PK Garner, Authority Volume 1, Tab 4, page 151. We see the policies in issue at page 156, paragraphs 18 and 19. There were two relevant policies. The first, paragraph 18, the Competent Authority Guidance dated the 24th of October 2013. And then paragraph 19, the Asylum Policy Instruction on Discretionary Leave, version 6, 24th of June 2013. Could I do the same exercise that I did in relation to Atamawan, and please ask the court to look at the Competent Authority Guidance. It's in volume 1 of the materials bundle, tab 5, page 300. And if one looks at page 301, under the heading About this Guidance, halfway down the page, there is a heading Council of Europe Convention on Action Against Trafficking in Human Beings, and we see that this guidance is based on ECAT, which focuses on, and then it gives a summary of the purposes of ECAT. And then the bit of the guidance that deals with leave is at page 397. There's a heading at the top of the page, Discretionary Leave on the Grounds of Personal Circumstances or to Pursue Compensation. And then there's a paragraph under the heading Personal Circumstances. If I could please ask the court to read that. And where it says see related link within that paragraph, that we understand it is a link to the other policy that the Court of Appeal referred to.
Just before we leave this page, it looks as though every page of the document has a header. This guidance is based on the Council of Europe Convention on Trafficking against Human Beings.
Yes, that's right. Which is a repetition of the sentence that I showed the court at page 301. It's just repeated.
Yes, but it's interesting that it appears on every page.
It is, yes. So the related link is to the other guidance document referred to by the Court of Appeal, and that is the document that the Secretary of State left on the bench yesterday lunchtime. I don't know whether the court still has that to hand.
Did you send it electronically, or did they send it electronically? I think they did.
I'm told they did.
And I'm told from behind me that it was sent electronically. That's version 6. We'll do it again if it's
No,
not.
it was over lunch yesterday.
Yes.
What date's this one?
The Court of Appeal gives the date as the 24th of June 2013.
Thank you.
It's a document headed discretionary leave,
Yes.
and rather charmingly referred to it was uncontrolled if printed.
Yes.
Yep.
I don't know whether my Lord the Master of the Rolls has that to hand.
Unfortunately not.
Could I hand up a spare hard copy?
I'm going to find it.
It's only one copy. We can
Couldn't someone in court just send it electronically?
I don't really... Okay, just carry on.
Page 5 of that policy document has a heading 2.4, trafficking cases, where one sees a grant of discretionary leave should be considered where a UK competent authority has conclusively identified that person as a victim of trafficking within the meaning of Article 4 of ECAT, and the individual's personal circumstances, although not meeting the criteria of any of the other categories listed, are so compelling that it's considered appropriate to grant some form of leave in line with the duration of grants of leave below. So that was the, as I'll show you in due course, that's what the court said was the 14.1a commitment. It then goes on in the second and third bullet points to deal with compensation and police investigation. And then if the court would please look at page 10. This is under an umbrella heading, duration of grants of discretionary leave. And paragraph 4.5 is headed trafficking cases. I could just ask the court to glance at the bullet points there. Those were the two guidance documents being considered by the Court of Appeal in PK Garner. And I would ask the court to note that those guidance documents didn't make any express reference to Article 14 ECAT. If we could please go back to PK Garner, page 158. I think the court's already been shown this passage, paragraph 34. The Secretary of State said in terms that the policy was intended to give effect to ECAT, and specifically to Article 14 of ECAT. And the effect of that, we say, is twofold. First, that as a matter of fact, the Secretary of State thought that her policy gave effect to Article 14. And then second, the Court of Appeal held that the policies at the time, on their true construction, did give effect to Article 14. And the Court must have been satisfied of that, because that was essential to the Court's declaration that the policy unlawfully failed to give proper effect to Article 14.
What were your two propositions again?
One, as a matter of fact, the Secretary of State thought her policy gave effect to Article 14. And two, as a matter of law, if it is a matter of law, the Court of Appeal held that the policy gave effect to Article 14. That's true construction.
I thought you said it made a declaration that it didn't.
Well, it sought to give effect. It, on the one hand, directed caseworkers to give effect to Article 14.
Intended to, but did not,
Yes,
which explains the declaration.
yes.
And your second proposition is probably, on Mr. Tam's analysis, still a statement of fact, but I'm not sure much turns on it.
No, it doesn't, and I don't press the point as to whether it's fact or law or something in between. The Court of Appeal held that the policy failed to give proper effect to Article 14 in two respects. One, in that it failed to identify what was necessary for the purposes of 14.1a. And that conclusion is page 162, paragraph 51. And then second, it set an excessively high threshold for the grant of a residence permit under 14.1a. That's page 163, paragraph 57.
Sorry, 57.
57. And again, as in Atamawan, the misstatement of what Article 14 required didn't mean that the policy intended to modify or limit the application of Article 14. But rather, on its true construction, the policy required caseworkers to give effect to Article 14. And to the extent that the policy went on to tell them to act in a way that was inconsistent with 14, that was an error. That then gave rise to it wasn't addressed by the court, but it conceptually gives rise then to the question that my Lord, the Vice President, asked yesterday, whether you read down the error or whether the policy has to be amended. In Atamawan, it was concluded that the policy had to be amended. So a declaration was made. that's all I wanted to show you on PK Garner. The third authority I was going to refer to at this stage is MN, which is in the same volume of authorities, tab 9, page 303. The only point I make by reference to MN is a factual one. Paragraph 71, page 303, we can see that the guidance that was before the Court of Appeal was the competent authority guidance published in March 2016. That isn't in the materials bundle, and I'm not proposing to examine the details of what that policy said. The only points I wanted to make are paragraph 72, that the Court of Appeal observed, second sentence, the section headed International Framework makes it clear that the NRM has been established in order to give effect to the UK's obligations under ECAT. And then page 306, how does that bear on the interpretive process when one's construing the guidance? Paragraph 85, since the NRM is avowedly intended to give effect to the UK's obligations under ECAT, the guidance must be construed so far as possible to give effect to those obligations. The kind of interpretive process that is analogous to Section 3 of the Human Rights Act, as my Lord Vice President suggested yesterday.
Yes, I mean, the sorts of niceties we've been looking at in this case didn't really arise, you know,
No.
because it was a big structural point.
Yes.
About the burden of proof, effectively.
Yes, so I can't rely on MN in the way that I rely on Atamuan and PK Garner, but I thought it was worth noting what the court said about incorporation of ECAT in that version of the guidance. So what does that context indicate? By context, I mean the previous versions of the guidance. We say that prior to making the guidance an issue in our case, it indicates that the Secretary of State had a general intention to comply with ECAT and a specific intention to comply with Article 14. And in my submission, if the policy in our case was intended to take a different approach, that would represent a significant departure from the previous position, different approach in the sense of not complying with Article 14. That would represent a significant departure from the previous position. And one would expect to see such a departure clearly identified. Could I then please look at what happened after PK Garner? Judgment in PK Garner was given on the 13th of February 2018. On the 21st of February 2018, in response to the judgment, the Home Office published interim guidance.
next
That-
day.
No, 8 days later. Judgment 13th of February, interim guidance 21st of February. And we've got the interim guidance, volume 2 of materials, tab 9, page 601. And one can see it's headed Interim Operational Guidance. And on page 603, heading about this guidance is for all caseworkers in UK visas and immigration enforcement, considering whether to grant discretionary leave to remain to victims of modern slavery. Then under the heading Publication, below is information on when this version of the guidance was published, version 1, 21st of February 2018. Changes from last version of this guidance. This is a new piece of interim guidance published in response to the judgment in PK Ghana. It supplements the guidance on discretionary leave to remain and victims of modern slavery competent authority. And then overleaf page 604. First paragraph, the Court of Appeal gave judgment in PK Ghana on the 13th of February. The case involved a challenge to a decision to refuse to grant discretionary leave to remain to a confirmed victim of trafficking. We need some time to consider the judgment and agree the way forward with the immigration minister. In the meantime, the actions set out in this notice must be implemented immediately on the 21st of February. There's then a heading, Refusals of Discretionary Leave. You must pause decision-making where you are not minded to grant discretionary leave to remain for any confirmed victim of modern slavery. So if you're minded to refuse, pause. And then the next heading, grants of discretionary leave. You may continue to grant discretionary leave to remain for any confirmed victim of modern slavery, those with a positive conclusive grounds decision as normal. The short point to make about this is that at least at this interim stage, there was no suggestion of any departure from the intention to grant leave in accordance with Article 14, now that the Court of Appeal had explained what Article 14 meant. After the immigration minister had had time to think about PK Ghana, version 2 of this guidance was published, and it's that version which was applied to KTT. And that's published on the 10th of September 2018. That same volume, tab 11, page 620. And one sees at page 623, under the umbrella heading about this guidance, we've got publication, version 2, 10th of September 2018, and then there is a heading, changes from last version of this guidance. The only change identified is clarification that Section 4 of the Scotland Act replicates Section 1 of the England and Wales Act. There is no identified change of approach in relation to Article 14 ECAT.
Now, when this says version 2, version 1
Was the interim version.
was the interim version.
It's a bit odd to call interim version 1 and then the final version 2, but that's the way it's been labelled.
Yes, I mean, it's obviously all done by a template, but it's also changes from the last version of this guidance. I mean, the last version of the guidance didn't say anything. It said, hold your horses till we decide.
Yes.
But anyway, there we are.
And doing the comparative exercise, my lord, I accept that version 1 is entitled Interim Operational Guidance, Discretionary Leave for Victims of Modern Slavery, and this one's simply entitled Discretionary Leave Considerations for Victims of Modern Slavery. But this is version 2 of the inverted commas, the interim guidance.
Well, it is what it is, anyway, yes.
So what's significant is to look at the identified changes. And as I say, no change of approach noted in relation to Article 14 ECAT.
Yes, but the change would not be from version 1. It would be from the previous guidance doing the same job.
Well, possibly. Possibly.
Because there wasn't previously a separate document all about discretionary leave considerations for victims of modern slavery. There was a bit in the general NRM guidance, and there was another bit in the general discretionary leave policy. Have I got that right? This is if you disregard the interim, which has no real content, this is the first separate published guidance about discretionary leave considerations for victims of modern slavery.
That's right.
But it has predecessors in the kind I've indicated.
As I showed my lord.
Yes, right. I just wanted to pin it down.
Well, yes. As a matter of language, one could read it as changes since the interim guidance, but I entirely accept the point that my lord makes, is that wouldn't make much sense, and it must be talking about changes since the last substantive version of the guidance. But either way, my point holds. Hitherto, the policy had been guidance to caseworkers had been, as properly construed, give effect to Article 14 ECAS.
Yes.
And there's no identified change of approach to that.
Yes, although the substance is in fact different, because they've tried to give effect to PK Garner.
Yes. Yes.
So it's all a bit, not criticising anyone, but so we can get it clear, it's all a bit of a muddled thinking, really, in identifying what changes, what it said it was or wasn't changing the previous position.
Yes, well, if one ignores the errors in the previous guidance, the guiding point was, to caseworkers, was you've got to give effect to Article 14.
Yeah, that's the point.
And that thread hasn't been cut. Then, staying on page 623, there is a heading at the bottom of the page, related external links. And though there are hyperlinks to the judgment, the Court of Appeal's judgment in PK Garner, and a hyperlink to ECAT. I'm so sorry, before I get to that point, I should have dealt with the point above. There's a heading related content, and that is to Victims of Modern Slavery Competent Authority Guidance, which, as we understand it, was the guidance that was considered by this court in MN, and which this court found was intended to give effect to ECAT.
So where's that?
That's the penultimate heading on page 623, related content.
Oh, okay.
I should have just dealt with that.
So that competent authority guidance, which my lord suggested was the predecessor, the true predecessor, taken together with the more general guidance, was not retracted, but added to.
No, my lord, as we read it, the previous guidance was the guidance that was considered in PK Garner.
And found to be wanting.
Found to be wanting, and that was then retracted. But sitting alongside that was the competent authority guidance that was considered by the Court of Appeal.
Is this the right way to look at it? I think at all times, frankly, at all times, I think, but at all times we're concerned with, there was a big document called the Competent Authority Guidance.
Yes.
Sometimes it's called the NRM Guidance.
Yes.
And that gave an overview of everything.
Yes.
And on some points, it gave not only an overview, but a lot of detail.
Yes.
Particularly how you identify victims of trafficking. But at some points, it said, it alluded to separate policies.
Yes.
And in this particular case, as we have seen, that document in all its various iterations, including very likely the one we had in MN, but we can't actually confirm this, because MN wasn't concerned with this aspect, said, on the question of whether to give leave to established or confirmed victims, see the discretionary leave guidance, which was a separate bit of guidance. And the exact parameters of the relationship between the overall guidance and individual spin-off guidances shifts from time to time over the history. But that's the way it works.
Yes, I think that's
Have
the
I
right
got that right?
characterisation. Yes. But the important point for me
Yes.
is PK Garner considered previous guidance, that's found wanting, that then leads to the interim holding position, that then leads to version 2 of the guidance, and version 2 says no changes. Save, of course, to correct the errors identified by the Court of Appeal. Where I had landed was the related external links. What do those links indicate? We respectfully adopt Mr. Justice Linden's analysis that the reasonable reader would conclude that they were there to indicate that the Secretary of State intended to take the approach set out in PK Garner. And the links were provided as a reference point in the event that a caseworker wanted to look at the relevant sources in more detail. That's Mr. Justice Linden's judgment, paragraph 76. Then back to this guidance document, page 626. Under the heading, leave is necessary owing to personal circumstances, we see the third line, the aim should be to protect and assist the victim and to safeguard their human rights. That reflects the purpose of ECAT as identified by the Court of Appeal in PK Garner. And then in the bullet point immediately below, there is an express reference to ECAT.
The only one.
There is, that's the only reference.
The only relevant one.
Only reference to the Trafficking Convention, but then if we look...
Sorry, I'm being slow. Where is it? Which bullet?
Bullet in the middle of the page on 626.
Single bullet, starting assess whether.
Oh, yes, sorry, yes, I've written over it or so much I missed it.
And then over leave, there is the first full paragraph begins additionally, and then 4 lines down, you may wish to consider that the UK's international obligations don't extend to the requirement that treatment must be provided by specialists in trafficking. Now, I accept that that's not it doesn't say ECAT, but in my submission, the reference there to international obligations must be a reference to ECAT.
I'm afraid I can't find it.
627.
Oh, it's in terms of needing to stay in the UK to have such treatment?
So the paragraph beginning additionally, the top of the page.
Yeah, got it.
You could probably track it. You might or might not reinforce your point by finding out what EM is about. I can't remember. I remember what it's about. I can't remember if it's based on ECAT or on the directive.
It was based on the directive, but there was reference to ECAT, and it was
It's slightly confusing because through most of this period, all the relevant period, international obligations had a dual source, ECAT
right.
and the directive. The directive, of course, being directly binding
Yes, that's right.
and saying much the same thing, although there are some marginal differences.
Yes, no, that's right. That's a fair point. And the reference there to international obligations might be a reference to the directive and ECAT, or both. I accept that.
And just to spell it out, you can correct me if I'm wrong. Oddity, for most of the history of the policy, there was only ECAT.
Yes.
At some rather late stage, we joined in the directive. We initially refused to sign up to it, or didn't sign up to it, but we did from a date which I haven't got on my fingertips. So that if one's looking at the early history, it's ECAT or nothing if you're looking at international obligations. But during the period we're concerned with, it's ECAT and the directive. Have I got that right?
I think that is right. But of course, the directive itself was based on ECAT.
Exactly. Yes, it clearly was. Yeah. But we said so.
I think
we
it
said
says
so in MN.
I think it also may say so in the preamble.
Yes.
To the directive.
Enough of this. I just wanted to make sure we got that right.
Yes. Those features of the policy, no changes, hyperlinks to PK Ghana and ECAT, and the reference to ECAT and then the reference to international obligations, we say taken together, strongly indicate that the Secretary of State required caseworkers to continue following PK Ghana to grant leave in accordance with Article 14 ECAT. Albeit now on a proper appreciation of what ECAT required in terms of necessary and threshold.
And you say give effect to ECAT, not just Article 14.
Yes, but for my purposes, I focus on Article 14. And to the extent that the wording at page 626 that Mr. Tam focused on, to the extent that that doesn't precisely track the wording of Article 14 ECAT, that in my submission can't properly be taken to represent a deliberate decision to attenuate or limit the domestic application of Article 14.
Quite the reverse.
Quite so. Just as the drafting flaws in the version of the guidance considered in PK Ghana didn't represent a limitation of the domestic application of Article 14.
Well, this is their third attempt. And at no stage in making this third attempt have they said, hang on a second, this is all going too far now. We're not attempting to implement the Article 14. What we're trying to do is a watered down version, and it's nothing to do with you because this is a treaty.
Exactly.
They could have done.
They had every opportunity.
Yep.
And then could we finally on this document please look at page 631. The fourth paragraph on that page begins all outstanding asylum decisions. All outstanding asylum decisions should be taken before any consideration is given whether the victim is eligible for discretionary leave. I think it's that part of the guidance that my Lord the Master of the Rolls identified, suggested that the quality of the stay had to be different from the one which I submitted as the proper construction of Article 14.
Well, it's that taken together. I mean, there is a a clear difference of emphasis in this document. You've passed over the really important bit, which Mr. Tam emphasised, which is at page 626, and it starts by saying discretionary leave may be considered where a competent authority has made a positive, conclusive grounds decision. And that's not what Article 14 says, right?
Well, sorry, my lord. We do accept that's what Article 14 says.
What? It's got to be a positive, conclusive grounds decision.
Yeah. My case is only about.
Now, I know your case is, but I'm thinking
Well-
of the case more generally.
Well, yes, there's a question to be asked, which is important for EOG.
Yeah, no, exactly.
But for my purposes, I'm perfectly content.
No,
to accept
I
this.
know, but I'm actually looking at what the document says.
Yes.
So the document delineates that there has to be a conclusive grounds decision,
Yes.
and then says leave is necessary owing to personal circumstances. Okay, 14(1)(a). Leave is necessary to pursue compensation.
Something else.
Hmm?
Something else.
Something else. Victims helping police. 14(1)(b).
Yes. So pausing there. So far, so good.
So far, so good. Then it says about human rights and safeguarding approach. And then it refers to the convention.
Yes.
They should assess whether a grant of leave is necessary to meet its objects under the convention, right? Which, so far, so good, really. I mean, that's certainly not drawing back from Article 14.
Yes.
And then it says, can't give all the circumstances, but these are the type of thing.
Yes.
And it's the first one, whether the person may be eligible for more advantageous form of leave for asylum and humanitarian protection.
Well, that in itself is unproblematic.
Well, you say it's unproblematic, but the way Mr. Tam argued it was to say that demonstrates that we're fully entitled to wait, and that in this period of delay, which wasn't contemplated by Article 14 or the treaty, we're fully entitled to wait, not give discretionary leave, until all applications have been concluded. And there may be a gap between provisional and conclusive grounds, and a further gap between conclusive grounds and asylum. So what this is effectively saying is don't think about this until you've got all the decisions in, and you can consider the longer term.
Yes.
Now, that seemed to me, when Mr. Tam was arguing it, to be quite a plausible explanation of what this was driving at. In other words, it was saying, don't do this exercise multiple times. We're thinking about a situation where there are not major delays. Maybe we shouldn't have been, but we are. And we don't want to give long-term permits under Article 14 to people who are at the interim stage of their journey, I can put it that way. Now, all that does seem to me to be a reasonable interpretation of what this policy is talking about. I mean, Miss Weston says that's not good enough because you've got to consider discretionary leave even from a provisional grounds decision. And you say it doesn't matter to you because at the very least it makes it clear you have to consider it after a provisional grounds.
After a conclusive grounds.
A conclusive grounds decision. But it's all a bit confusing as to, I mean, your point up for this argument, I understand, is simply, well, there's nothing in this that says they're not trying to implement Article 14, and if they are trying to implement Article 14 and have made a mistake, that's fine, you can correct it.
Yes. My lord, can I address head on my lord's point about that first bullet point on 66? Where it says whether the person may be eligible for a more advantageous form of leave, for instance, asylum or humanitarian protection, that in itself says nothing about scheduling. It says nothing about don't grant
Sorry,
and
what
wait
does
and see.
scheduling mean?
Oh, sorry,
you mean timing?
timing. It says nothing about timing. It simply says on its face, or it can be read as simply saying on its face, if you're considering discretionary leave at the same time as considering an asylum claim, if you're going to grant long-term leave in respect of asylum, it's pointless to grant discretionary leave as well. It just becomes OTOs. Now, I absolutely accept that that takes on a different hue when one reads it in combination with what is said at page 631. Absolutely. But that's why I have focused on 631 and those two lines at page 631. And as I'm going to show the court in a moment, by the time we get to the decision in KTT's case, that provision had been quashed. But returning for a moment...
That's the provision that gets quashed
Exactly.
here by Mr. Justice Murray.
By Mr. Justice Murray. And I'm going to come to that in a moment. But I want to take it, if I may, chronologically. But coming back to page 626 and looking at what those bullet points say on their own terms, the first bullet point, as I say, in my submission, doesn't say don't grant leave if there's a pending asylum claim. And in fact, to the contrary, when one looks at the second and third bullet points, it requires caseworkers to consider the points that I say ought to have been considered in KTT's case at that time. Whether leave is necessary because there's significant and real risk, and whether if returned home the person would face ill treatment. Now, where there is a pending asylum claim, where the asylum claim is solely based on risk of re-trafficking, there is a statutory presumption, absent certification, of a real risk of re-trafficking. So those second and the third bullet points in my submission are satisfied in a case like KTT's. It's only the scheduling, as I call it, the scheduling rule, the wait and see rule, which prevents consideration of those points. So the inconsistency between this guidance and Article 14 of ECAT, in my submission, came down to the two lines at page 631.
The first two lines of that, of the all outstanding.
Yes.
Okay.
And it's that issue that was confronted in JP's case, which I'm now finally going to come to.
You say, by the way, as regards the first bullet point, so you say it's not on 626, it's not really problematic for you for the reasons you've explained. It's just the case, isn't it, that although these decisions are all taken in the Home Office, the decision taker in relation to the grant of discretionary leave will not be the decision maker in relation to the asylum claim. Or am I wrong about that?
I don't know the answer to that, my lord. I suspect the answer is it may or may not be, but I don't know.
Yes, I see.
I'm told that from the experience of my instructing solicitor, it's usually not the same decision maker. It's usually not the same Home Office official.
Generally, trafficking questions are dealt with wherein that has this rather odd phrase, the competent authority, which is basically the trafficking unit within the Home Office. And asylum comes under a different unit. I appreciate this is in between, because this is actually a discretionary leave decision in relation to trafficking, but I don't know who takes it, and I don't think the evidence shows.
No.
You're entitled to say it's all the Home Office at the end of the day. They can talk to each other. Yeah.
I don't think it affects my argument.
No, probably
One
not.
way or the
But I
other.
just wanted to be clear.
So JP, unless there's anything else on the policy document, JP is Authority Volume 1, Tab 7, page 227.
On the 10th of December, 2019.
If one looks at page 235, paragraph 34, one sees in the first line, the scheduling rule. That was the...
So, sorry, which page are we on?
Page 235, paragraph 34. Well, I should say, one can see at paragraph 33 what the scheduling rule refers to. It's those two lines of the policy that I've identified. That was given the shorthand, the scheduling rule. And then paragraph 34, the scheduling rule and the criteria for granting ECAT leave are set out in a policy document published on the 10th of September 2018, Discretionary Leave Considerations, version 2. That is the policy we've just looked at. And then the scheduling rule is set out in the first sentence of page 12. That's the sentence we've just looked at. If we could please turn back to page 231. Just below letter H, we see in her detailed grounds of defence for each claim in this case, there were two claimants, the Secretary of State stated that the published policies, and of course we're talking here about version 2 of the guidance, came into being to give effect to Articles 10, 12 and 14 of ECAT. And it then goes on to deal with the consequences of that for justiciability. I emphasise that the Secretary of State told the court that this version of the guidance was intended to give effect to, among other things, Article 14 ECAT.
You need to draw our attention, perhaps you were about to what it said. The next page, the Secretary of State's position in this case, is constrained to follow this concession but reserves her position for the future.
Yes, it's difficult to know whether the concession there is relating to justiciability or concession of the fact. It's a bit odd to reserve one's position on the fact of whether the Secretary of State intended to comply with ECAT 14 when making the policy. One might expect her to know that.
I mean, I don't, yeah, okay.
And then, if I could follow this through, page 236. Paragraph 36, Mr. Justice Murray says in my respectful submission correctly that the effect of the scheduling rule is that a victim of trafficking who is also an asylum seeker won't have their application for ECAT leave determined until their application for asylum has been granted and then a decision on refugee leave has been made. That was the effect of the two lines that we've looked at. Then at page 253, paragraph 136, the decision was, in my view, the scheduling rule as currently formulated isn't consistent with the obligations of the UK under Articles 12.1 and 2 and 14.1 of ECAT. And so just pausing here, could I make the point that I've already made in relation to Atamawan and PK Garner? That the finding, Mr. Justice Murray's finding, that the guidance was in certain respects inconsistent with Article 14, represented a failure to give proper effect to the intention to comply with Article 14. It didn't represent an intention to introduce a modified version of Article 14.
And why did he say that? Not what you've last said, but why did he say that the scheduling rule wasn't consistent with the obligations in terms of when a discretionary leave decision should be considered?
There were a number of strands to his reasoning. The first strand was that at that time, the Secretary of State ceased providing any form of trafficking support 45 days after a conclusive grounds decision. And so the effect of deferring consideration of leave until the asylum decision would be to leave the victim without support provided for by Article 12. But there was a second strand to his reasoning, which was that the uncertainty of status that resulted from the scheduling rule was inimical to the recovery of victims and was therefore inconsistent with the intention of Articles 12 and 14.
But in a situation where support is provided, is that the case now?
No. So the 45-day rule has gone.
That's what I mean.
Yes, it's gone. So
in a situation where the first reason goes, support is continued to be provided after conclusive grounds. The uncertainty of status point is well, anyway more nuanced.
Yes.
And that, I mean, I'm just thinking aloud, but in theory, you could reach a different conclusion.
Yes, my lord, I don't, it forms no part of my argument in this case that if the court were considering a scheduling rule now, it would necessarily have to reach the same conclusion as Mr. Justice Murray. It would need to consider the more nuanced point that my lord refers to. All I'm relying on JP for is to show what the Secretary of State said about the intention of version 2 of the policy and what Mr. Justice Murray in fact did.
I know why you're relying.
I don't rely on the question of whether that reasoning could be transposed to a different hypothetical situation or the situation that might now exist.
I mean, you with respect, summarised the two strands pretty accurately, but the uncertainty was very specifically, it wasn't just the general uncertainty, it was the uncertainty in circumstances where there was such a long delay.
Yes.
And there's a lot of evidence about the length of the delays, yes. And that's an essential part of his reasoning.
Yes, and there was psychiatric evidence as to the profoundly adverse impact that had on victims.
the inevitable uncertainty of not knowing what's going to happen over a short period would not have, he was not part of his reasoning.
No. No. So I rely on the fact of what Mr. Justice Murray found, rather than the question of whether his reasoning would be transposable to the situation now, if such a claim were to arise now. What I can, I think, properly rely on is that having found the policy intention to be compliance with Article 14, but then the policy being flawed in a respect in its application of Article 14, Mr. Justice Murray didn't conclude that indicated that the intention was to modify the application of Article 14. That I think I can rely on, regardless of...
You can also come back to your seventh, or whatever it was, point of yesterday, which is Article 14.5.
Yes. Well, that is... The submissions I made yesterday were all directed to the true construction of Article 14. Now I'm just looking at whether the policy intention was to give effect to Article 14 as contained in ECAS.
Yes, I know what you're saying, but what you're saying, what you're submitting, does have an impact on the other case.
Yes. The Secretary of State didn't seek to appeal against Mr. Justice Murray's decision.
Didn't even ask for leave.
I can't remember whether Mr. Justice Murray was asked for leave, but certainly there was no application to the Court of Appeal. Oh, I think I can say with reasonable confidence that Mr. Justice Murray wasn't asked for permission to appeal because we've got the order that he made, which I was proposing to hand up in a moment.
You did this case?
Yes, I did.
What we can see from this, when it appears, is that he didn't refuse permission, which suggests it wasn't asked.
Quite. Yes. Now, before I come to the order, just to set this position chronologically.
I mean, just since you've handed this up.
Yes.
He declared that the defendant breached the rights of the first and second claimants under Article 14.
ECHR.
Yes. Oh, ECHR. Yeah.
Because they were treated less
Yeah,
favourably.
No.
So the bit that concerns us is paragraph 2.
Yes, sorry, yes, that was you. In the interest of economy, you haven't pointed out to us there was also the other Article 14 claim.
It doesn't concern us. The claimants were treated less favourably on the ground of being asylum seekers than victims of trafficking who didn't claim asylum, because they had to wait for their ECAT leave decision, whereas fair victims of trafficking didn't. That was the Article 14 of.
And there was no logical justification for that.
And there was no justification. But that doesn't concern us. The bit that I wanted to show the court in the order was paragraph 2 of the order, that the sentence that we've looked at, the scheduling rules sentence, was quashed.
So was the guidance version 2 reissued?
No. I'm going to come on to explain what the Secretary of State's position was on the guidance in light of JP. Before I do that, could I just set this chronologically? As my Lord the Master of the Rolls noted, judgment in JP was given on the 10th of December 2019. The discretionary leave decision in KTT's case was given on the 17th of August 2020.
And when was the application made?
For discretionary leave.
Yeah.
I'll have to look to those.
Sorry to.
Are you obliged to make an application for discretionary leave as such? Perhaps you are, but I know the guidance seems to say, if you grant conclusive grounds, you must consider it.
I'm told that's correct. It's an automatic consideration following the conclusive.
So they don't require you, even for form's sake, to fill out an application.
I think
That's when you're about to be told the answer.
That's not an application, that's just...
one is sent a form requesting information. Single competent authority sends a form requesting personal details, but that isn't a prerequisite to consideration of leave.
Yes. And
There's
it's
no
not, strictly
application.
speaking, an application like one sees under the rules.
Exactly so.
Yeah. Okay.
So, and you got your positive conclusive grounds on the 31st of October 2019. Well, according to paragraph 2 of Mr. Justice Linden, anyway.
Yes, well, he got it right. I don't have the date. 31st of October 2019, yes.
And then DL is refused on 17th of August 2020.
Yes. And so I make the observation that that's 9 months after JP was decided and that sentence was quashed.
And your ground 1, in some respects, mimics JP. Or what you were seeking in JP.
Well, it has parallels, yes. Now, the Secretary of State could, in the intervening 9 months, have amended her policy to provide that she didn't, after all, want her caseworkers to determine applications for discretionary leave in accordance with Article 14 ECAT. She didn't do so. Now, could I come to the effect of the quashing order? The Secretary of State's position was that the quashing order automatically amended the guidance to remove that sentence. And so there was no need to issue revised guidance.
That's a very confusing approach.
Well, that was certainly the KTT's position, and a complaint was made about that in KTT's pleadings. The Secretary of State's response in her detailed grounds of defence in KTT's case, signed by leading counsel, is in the core bundle. At page 402. Paragraph 1.5, the Secretary of State notes the pleadings of 153 of the grounds. That was complaints about the failure to amend the guidance. The Secretary of State doesn't agree with the allegations the claimant makes about the policy, which was itself amended by the order following JP&BS, and so required no amendment. And it then goes on to deal with a new policy. Well, that was version 3, but version 3 wasn't in force at the time of KTT's decision.
When did version 3 come into force?
9th of October 2020.
Does it deal with this anomaly?
I think it does finally delete that sentence.
But what does it say about when discretionary leave should be considered now?
Well, I'd have to turn it up. It doesn't form part of my case, what it said, because it's all after the event. But
No, but it's interesting to know the context.
yes, of course.
it might be right to say as a matter of jurisprudence that it does automatically delete it, but obviously the poor caseworkers won't know that.
No, no. It's
I would like to think that at least that happened with some sort of circular went round. But
we
and of course that isn't wholly satisfactory because I'm right in thinking that the guidance is formulated as guidance to caseworkers, but it's long been accepted that it is also a statement to all the world.
yes.
Which is necessary for them.
Well, as the Supreme Court said in Lumber, there's an obligation to publish guidance precisely because individuals may want to make representations
Right.
in light of what the
And
guidance
they need
says.
to know what rules are being applied.
Exactly.
Yeah.
But my lords, I'm not seeking to make a complaint. I'm not seeking to make a complaint about the failure to publish an amended version of the guidance which removed the offending sentence. The point I'm simply seeking to make is that the Secretary of State herself accepts that by the time KTT, the decision was made in KTT's case, version 2 of the guidance no longer contains the scheduling rule. And so what one is left with is, in my submission, an Article 14 ECAP compliant policy.
So for KTT, we shouldn't have been shown page 631, the 2 lines on 631.
Yes, they didn't exist legally.
If you say it's Article 14 compliant, to take into account the possibility that asylum, that a better form of humanitarian protection or asylum may later be granted.
Well, so long as you don't shut your eyes to the obligation to grant leave if the person's stay is necessary for a convention reason.
Wait. Doesn't it follow from your case that you would have to grant leave? You know, suppose the position were that he picks up the phone to the asylum decision maker, assuming it's not himself or herself, and says, well, are we going to get a decision on this soon? And the person at the other end says, yes, we're expecting a decision next week. Maybe even says, and I can tell you privately what it's going to be, but that's not, I think, essential to the example. What's the position then? Is the decision maker on leave now entitled to say, well, I think it's very likely he's going to get leave very shortly, asylum leave, and I'm not going to spend the administrative effort of giving him discretionary leave, which will be superseded in a week's time?
So I think the question is whether it falls into a de minimis principle. If it doesn't fall into a de minimis area, then yes, the answer is yes. One does need to grant leave in accordance with Article 14, if that's the policy. The question is whether it's for a legally significant period. Now, whether or not a week is a legally significant period may be a question that arises in another
yes,
case.
I wasn't putting this just to be tricky. I was putting it because you were talking about you've got to have your eye to the possibility of. But I don't realistically know what that the possibility of a more advantageous leave being given or taking it into account. But the truth is, unless you know that it has been taken into account, in which case I agree.
Unless you do it at the same time.
Yes.
Yes.
You're actually saying it's an absolute duty subject to the de minimis principle.
Absolutely.
Yeah,
but
okay.
the question I'm addressing at the moment is, can you read the policy compatibly with Article 14? Well, as long as you read the policy in the way that we've just discussed, then yes, you can. What one can't do is give that first bullet point on that page the different hue that it took on in light of the scheduling.
Yeah. Well,
So I mean, you say the way to read it compatibly with Article 14, to which you say it gives effect. is by saying that really, subject to the week scheduling, the decision has to be made at the same time. And if you're going to grant asylum, give them asylum and refuse them discretionary leave. Otherwise, if you are necessary, you are necessary and get leave.
Precisely.
Yeah.
Well, yes, I see. But likewise, of course, if you refuse asylum, then
Then
on
you
this
get,
aspect of your case, you're not entitled to discretionary leave.
Well, subject
Your
to
stay ceases to be necessary.
subject to certification. Subject to certification and appeal rights.
Yes, subject to appeal. Yes, I see that.
Because if there's an appeal and it's not certified, then there is a deemed risk of re-trafficking in the country of origin.
well, there may be a risk of re-trafficking because that's the reason for not certifying. Otherwise, you're putting certification too high a test.
Yeah.
There may be a risk, and your stay is still necessary so that you can pursue your challenge to that. I think I didn't pick you up on it before, but you're putting certification too high if you say it's just that there may be a risk which needs to be judicially determined.
The real point is you can't be removed pending your appeal, which, unless certified, you are entitled to.
Yes, but
And in those circumstances, your stay is necessary.
yes, I think my lord is absolutely right to say that I put the level of risk too high. But the point that the Supreme Court made in Re G is it is to guard against risk of re-trafficking in this situation, whatever the precise threshold.
Where there is a real possibility or a possibility that a tribunal may find that established. Yeah.
Exactly. So I'm almost there. I just wanted to show the court one more thing, which I think the court is, judging by an observation that was made yesterday, the court already has in mind, and that is what the Secretary of State said about the policy, about this version of the policy, version 2 of the policy, in the EOG proceedings. And if we could please look in the supplementary bundle, volume 1, page 409. This is a witness statement given in the EOG proceedings by Russell Bramley, who describes himself as the policy manager in the Home Office Modern Slavery Unit, specifically leading on NRM policy and sustainability. And then if we could please look at page 413, I think the court may have already turned this up. At paragraph 12, Mr. Bramley refers to version 2 of the discretionary leave policy, dated September 2018, so the policy that was applied in KTT's case. And then on the 7th line, he says, the policy exists to reflect the requirement in Article 14(1)(a) of ECAT, to consider whether a grant of discretionary leave is necessary owing to the individual's personal situation. Now, this was the view of the relevant policy team in the Home Office in respect of the policy that was in issue before Mr. Justice Linden, unfortunately wasn't disclosed in KTT's proceedings. We only discovered it because we happen to have been linked to EOG.
That sounds like a complaint.
It's a mild complaint. But for what it's worth, that's what the policy units say about this version of the policy. I can attempt to deal with the court's question about the timing in EOG's case, but I've heard sotto voce that perhaps Ms Weston would prefer to deal with it.
If the court will permit me.
Unless there are any other questions that arise, those are my submissions.
No. Thank you very much.
We asked Amanda Weston to deal with that.
Yes, if you can deal with it now, Ms Weston.
I'm grateful. So the two policies which were in play at the date of the decision in this case, the date of the decision itself is the 12th of September 2019. And so the two policies...
Sorry, which decision?
That's the decision to refuse the request to extend leave or grant leave.
To refuse discretionary leave on which date? September?
12th of September 2019.
Yeah.
So the two policies which are in play are found at tab 11 and 12 of the policy bundle. And they are the policies that the court's been taken to by Mr Butler.
So they're version 2.
Yes, so it's what the Vice President has described as the general NRM policy is the one which is at tab 12, electronic bundle 639, which is version 7, published on the 29th of April 2019.
Sorry, just give me a second.
639.
That's right.
Thank you.
And the reference to, the cross-reference to discretionary leave, we see at 647. And that states that cross-referencing guidance refers to circumstances in which it may be appropriate to grant discretionary leave to individuals confirmed as victims of modern slavery. We say that reflects what Mr Bramley understood the position to be about the purpose of that policy. And then if we go back to tab 11, we can see that by the time the decision in respect of this individual was made on the 12th of September, there was an updated version of the policy which is in play at 620. And that is version 2 that the court just referred to. And we can see at the bottom of 625 the subheading, when to consider a grant of discretionary leave. Over the page at 626, discretionary leave may be considered where a competent authority has made a positive conclusive grounds decision. My learned friend has taken the court to...
Sorry, where were you reading from?
Second paragraph down on 626.
Yeah, thank you.
So, my learned friend has just taken the court to Mr Bramley's statement. Because the court referred to it in terms and its contents in my submissions, I didn't take the court to it at the time, but we say it's clear, tolerably clear from Mr Bramley's statement that DL, the separate DL policy, that's the policy, the cross-reference policy to which version 2 I've just taken the court, is expressly dealing only with the situation after you've got a CG. And indeed, that was the position of the Secretary of State before Mr Justice Mostyn.
This is all uncontroversial, isn't it?
Yes. Well,
That's why you wrote a case.
well, yes, but I just wanted to check because I was listening to what my lord, the MR, was saying about the potential interrelationship between the submissions made in respect to the two cases, and simply wanting to delineate why we say that there was a rigid rule in respect of the particular complaint of EOG, but for the purpose of completeness, we find the Secretary of State's position at paragraph 21 of the detailed grounds of defence, which is in core bundle 187. I don't know if I can assist any further.
No, thank you very much. Very good. Now Miss Christie is next, I think.
The Air Centre is very grateful to the court for the opportunity to intervene in EOG's appeal and the opportunity to make short oral submissions.
You're going to have to speak up a bit, Miss Christie, because you're...
I was just expressing our gratitude for permission to intervene and to make oral submissions today. I don't intend to make submissions on justiciability, save to emphasise that, as set out in our written submissions, the government has made a clear and specific policy commitment to comply with Articles 10, 12 and 13 of ECAT, and that the government has not resiled from this in any published policy or guidance, in evidence, or by way of submissions in this hearing. I do want to address you on the content of the obligations under Articles 10, 12 and 13 of ECAT. Firstly, on the narrower Article 13.1 obligation to formally authorise the stay of a victim during the recovery and reflection period. And we do say that this is a freestanding issue, although we say it's not the end of the Secretary of State's obligations. And secondly, on the obligations arising under Articles 10, 12 and 13, and why we say that in at least some circumstances, the Secretary of State will need to grant temporary leave to comply with those obligations, and why the current policy framework is deficient.
Is sufficient.
Deficient.
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 And lastly, I have just a couple of very brief points to make about Article 4, which I don't anticipate taking very long.
Okay.
So my first submission is that Article 13.1 requires the Secretary of State to formally authorise, by the provision of documentation, the stay of a victim during the recovery and reflection period. And the current legal and policy framework does not comply with this obligation.
So that's immediately after a reasonable grounds decision.
Yes. And I'll develop this submission by making four broad points. Now, the first point concerns the difference between Article 10.2 and Article 13.1. Article 10.2 covers the period between the positive reasonable grounds decision until the conclusive grounds decision. And as we've seen, it contains a negative obligation not to remove an individual during this period. And it's not in dispute that the Secretary of State complies with that negative obligation. It's set out in the guidance that an individual won't be removed. Article 13.1 covers the recovery and reflection period. And we know that ECAT says that is a minimum of 30 days.
From when to when?
30 days from the grant of a reasonable grounds decision. That is what is required at a minimum by ECAT 13.1. We've seen in the explanatory report that Greta recommended a period of 3 months. Different countries take different approaches. In the UK, victims are granted a minimum of 45 days. In the UK, the period, recovery and reflection period under 13.1 and the period under Article 10.2, pending a conclusive grounds decision, are coterminous. And that is because the Secretary of State's policy is to grant a recovery and reflection period until she makes a conclusive grounds decision. but it's not necessarily the same period under ECAT.
Well,
And
to make that good, it's hard to. I've started, so I'll finish. It's hard to see what status ECAT intends someone to have between the end of 30 days, which, as you say, is all ECAT requires, and the making of a conclusive Crown's decision. Forget all this talk about long delays. The ECAT can never have thought that in every case you would have a conclusive Crown's decision at the end of 30 days. So surely ECAT must have contemplated that what I might call the Article 13 period was in effect the same as the Article 10.2 period, because otherwise what rules, what regime would govern in the gap between the two?
it may well have been contemplated that that period would be the same period. But the reason that I'm drawing attention to the fact that on a strict and proper analysis we say of ECAT, there is a difference in what is required by Article 13.1, and that Article 13.1 does add something to the negative obligation not to remove that is found in Article 10.2. And so I'm making this point to go on to support my second point, which is what we get from Article 13.1. And we say, my second point, we say that Article 13.1 contains a positive obligation, and I refer to the final sentence of 13.1, which the court has seen. It says, during this period, the party shall authorise the persons concerned to stay in their territory. We say that is more than simply not removing. And the court has already had a look at paragraph 178 of the explanatory report. But if you don't mind, I'd ask you to go to it again, just so I can emphasise a couple of points. It's in the Authorities Bundle, Volume 2, Tab 15, page 622. And the third line down, although free to choose what method to employ, parties are required to create a legal framework allowing the victim to remain on their territory for the duration of the period. To meet this end, in accordance with national legislation, each party shall provide victims without delay with the relevant documents authorising them to remain on its territory during the recovery and reflection period. And we say this makes the obligation 13.1 crystal clear that the government is required to formally authorise, by the provision of documentation, a person to remain in the UK during the recovery and reflection period.
And you're probably going to answer this later, but in which case I'll wait. But what would the content of such an authority be if it goes beyond non-expulsion,
I will come on.
but is not the same as residence permit?
I'll come on to address you.
Okay.
To an extent, it may be answered by my next point, my third point. I just want to set out the background to how the Secretary of State used to direct caseworkers to grant temporary admission or temporary release and issue a form known as an IS 96. And can I ask the court to have a look at the guidance for competent authorities? The very first version is at Policies Bundle, Volume 1, and it starts at page 77. This was in force from the 13th of October 2010. And just by way of clarification, we understand this to be the very first guidance document formally issued for the competent authorities. But it was then, subsequent to this, there was what was called the Competent Authority Guidance, which was called version 1. and that went up to version 8. So we say there have actually been 9 versions of guidance.
This is version 0.
Authority. Version, let's call it version 0.
Which page is it at again?
Starts at page 77 of the policies bundle. I'd like to ask the court to have a look at page 101. The heading at the bottom of the page says reasonable grounds outcome, person accepted as a potential victim. And you'll see the last line says the 45-day reflection period is then initiated. Over the page, on page 102, I'd ask the court to have a look at the first and second paragraphs. They cover the grant of temporary admission, temporary release, the issuing of the IS 96.
Yeah.
If the court can then turn to page 106. At the bottom of the page, headed improper claims, it makes reference to Article 13.3, which permits states not to observe the period of recovery and reflection on grounds of public order or if victim status is found to be claimed improperly. And over the page at 107, it says if this is so, the period of reflection will be curtailed and the officer should initiate immediate withdrawal of the temporary release and admission. And then further down the page, requests for extensions deals with when a person requires a further period of recovery beyond 45 days, in which case the competent authority should consider whether an extension of TA or TR is appropriate.
Can you just help me on 102? It all starts if they're in detention. Suppose they're not in detention, but don't have leave to remain, which must be quite a common situation. They might be liable to be detained, but they nevertheless may not have been.
So
does this actually spell that out, or you just say...
It doesn't spell it out, but what I was going to do is give the court a bit of a background overview and explanation of temporary admission and temporary release, because the way in which this policy is worded, I think, doesn't clearly explain what in fact was given to people at the time.
Is the answer not on page 101, which is the caseworker updates the case information database with the reasonable grounds outcome updated, and they issue the decision letter?
Yes, but I understood my Lord Vice President's question to be going to what happens when a person isn't in detention, and I just wanted to explain the ways in which temporary admission and temporary release were granted, because that may be helpful, particularly when we come on to consider immigration bail. So, in the United Kingdom, if a person does not have the right of abode, they have to be granted leave to enter or remain in the country, in order to live in this country. And yesterday, Mr. Weston handed up Section 1 of the Immigration Act 1971. There are various exemptions, so individuals falling within the common travel area, Irish nationals, are free to enter. Crew members of ships and aircraft have a limited period within which they can enter the country.
And at the time we were concerned with EEA nationals.
EEA nationals.
Who didn't have, they fell outside the whole regime.
Exactly, and diplomats who'd be exempt. But everybody else requires leave to enter or remain. However, the presence of certain persons without leave to enter or remain was temporarily tolerated until a decision is taken on whether to grant them leave to remain. So, for example, asylum seekers would be granted temporary admission, but also persons who were to arrive at the UK border and not satisfy an immigration official that they had leave to enter, they may not be detained. They may be granted a period of temporary admission with certain conditions attached, reporting restrictions, and told to report back, at which point a decision will be taken as to whether they're going to be granted leave to enter or they're going to be removed. So people who were detained and subsequently released were granted temporary release. Individuals who weren't detained were granted temporary admission. They were temporarily admitted to the country. And those are the forms of immigration status for persons who are authorised to be in the UK. Either you have leave or you had temporary admission or temporary release. And this status of temporary admission, temporary release was replaced by the status of immigration bail on the 15th of January 2018 by the Immigration Act 2016. And we've set this out. I'll just give you the reference at footnote 14 of our submissions, which is at page 96 of the Skeletons bundle. And the purpose of immigration bail, set out in the immigration bail policy, is to facilitate the return of individuals with no legal basis to remain in the UK. And if you're granted immigration bail, you're given a specific form. It's called Bail 201. And it sets out your conditions of bail, how frequently you need to report, prohibitions on working, there may be a residence requirement, etc. And it is a criminal offence to breach those bail conditions without reasonable excuse. And that's section 241H of the Immigration Act 1971. For your note, it's Authorities, Volume 2, Tab 17, page 666 to 7. An individual can face a fine or imprisonment of up to 6 months. So my next and fourth point.
Sorry, just so that I understand, an asylum seeker arriving in this country after the 15th of January 18 is granted immigration bail, pending. That's the form used for asylum
That's right.
seekers now, is it?
That's right.
And likewise, people who arrive at the airport and there's a question, but they don't want to send them straight home. Same form. So it's really just another, but it does the same job in a slightly different way as temporary admission, temporary release.
Exactly.
Okay, thank you.
Exactly. So my fourth point just develops the chronology of this. This competent authority guidance continued to direct caseworkers to grant temporary admission or temporary release from versions 1 to versions 4. And then version 5 was published on the 21st of January 2019. And this instead referred to immigration bail. So there was a direction to caseworkers to grant immigration bail, which reflects the change that came about by the legislation. In early 2019, this guidance was amended. We haven't been able to find a copy of version 6. I suspect that's because it was only in force for a very short period of time, because version 5 was in force from the 21st of January 2019, and version 7...
Sorry, what was the date?
21st January 2019.
Yep.
And version 7 came into force on the 29th of April 2019. And that's where we see a change. So the Secretary of State no longer instructed competent authority caseworkers to grant temporary admission or immigration bail to victims during their recovery and reflection period, but instead required them to refer to immigration teams to consider immigration-related issues, including immigration bail. And I'll give you a reference. It's Policies Bundle, Volume 2, Tab 12, page 701. That's the direction in version 7 of the Competent Authority Guidance.
Refer to immigration caseworkers to make an immigration decision.
Yeah. And that direction has been maintained and is found in the current Modern Slavery Act Statutory Guidance, version 2.5. And I'll just give you the reference. It's paragraph 14.205, which is at Policies, tab 18, page 1349.
What page?
1349. However, the Secretary of State did not issue any guidance to immigration officials on granting immigration bail to victims during the recovery and reflection period. The immigration bail policy doesn't contain guidance on granting bail to potential victims during the recovery and reflection period. It refers to asylum seekers, to illegal entrants, but it doesn't say anything specific about directing immigration officials to grant bail to potential victims. It doesn't say what conditions might be appropriate in their circumstances. It's entirely silent.
The group who fall through this guidance loophole are victims of trafficking who are not UK or Irish citizens and have no other leave to remain. Because many
victims who have no other leave to remain.
Yeah.
Victims who are not also asylum seekers, because if they are asylum seekers...
No, that's the point. I'm sorry, I'm just spelling it out myself. Is that so? If they're asylum seekers, they ought to get immigration bail.
If there's one other category. If they're not asylum seekers, but they're victims of trafficking who happen to have been detained and are released from detention, then through the process of being released from detention, they will be granted immigration bail. But anyone who is not an asylum seeker and not detained will not, and is not, we say, being granted any form of authorisation to stay.
So it's a limited but real group.
It's a limited but real group. And that's set out in the witness statement of Matthew Evans, the director of the Air Centre, which is in the core bundle at page 84. That's his experience, the experience of the Air Centre, but he also notes the experience of other practitioners working with victims of trafficking. And on the question of Mr. Evans' statement, you should note that my Lord the Vice President directed in August last year that this statement could be included in the bundle, but the question of whether or not we have permission to rely on it hasn't yet been resolved. I simply say that there's relevant information there. The Secretary of State has had it since June last year. It hasn't been opposed or rebutted in any way, and we consider that it is of some assistance to the court in giving a fuller picture of the practical position on the ground. The court has already seen EOG's recovery and reflection decision letter. I believe another example, anonymised example, was provided. KTT's letter is also in the supplementary bundle at page 567. These letters say nothing about a person being formally authorised to stay in the UK. They say nothing about their conditions of stay or their length of stay.
Yeah. If the system worked, as you were, I think, implicitly saying it could legitimately work, it wouldn't. You probably wouldn't expect it in that letter. You might expect it in a different form of document, but that would be a document.
You'd expect it in the bail. You'd expect a bail 201. That's the only way under the current framework for the Secretary of State to authorise stay without granting leave. And and that was why I took the court to the explanatory report, saying that while states have discretion as to the way in which they do so in compliance with their national framework. And that's why I explained to the court precisely what the framework is in this country.
The way, forgotten KTT circumstances, in EOG circumstances, she did actually, when she first made her claim to be a victim of trafficking, have leave to remain, so she didn't need. But the system would have to, you would say, allow for the issuing of a document of this character at the moment that leave expired and was not renewed.
Yes, and if you take the case of overseas domestic workers, by legislation, those individuals have their leave extended. So it's not a question of authorisation to stay and their presence being tolerated. Their leave is actually extended. There is,
under Section 3C.
It's I believe a different provision within.
Oh, is it? Okay, don't worry. No, I don't want to put you down.
This particular cohort of victims of trafficking have a special provision whereby if they do have leave at the time a reasonable grounds decision is made, that leave is extended.
Oh, I see. Okay.
But there is no similar provision for any other category of victims, and it doesn't apply to overseas domestic workers if there's a delay in the Secretary of State making a reasonable grounds decision, and that by that point their leave has expired. So our submission is that Article 13.1 gives individuals a right to formal documented authorisation. They have an individual right to it. It also assists with ensuring that third parties understand the correct legal position. And so
we've asked both counsel for examples of where it could actually make a difference as regards third parties.
Well, we would say that the education example that Miss Weston explained to the court is one example. Police is another example. As I've set out, there was previously an authorisation document called an IS-96, and it's now Bail 201. These are documents which police and immigration enforcement do or ought to know and recognise and understand to be a document fitting within the immigration framework governing presence in this country. But the letter saying you've been given a recovery and reflection period is not such a document. And there is at least a very real risk that an individual who is apprehended by the police or immigration enforcement and says, well, hang on, I'm in a recovery and reflection period. There is no policy directing immigration. Let me amend that submission. To my understanding, immigration enforcement will not necessarily know that an individual.
It's not what they're used to. They're used to seeing. Here's my immigration bail. They look over it. Oh, that seems all right.
Exactly.
Yeah. Can I just go back to the question I asked you a few minutes ago? You said it might be partially answered by the answer you've just given. I asked, what is the content of authorisation? Thus far, I explained, see exactly what you mean in terms of paperwork, and I'm not diminishing the importance of paperwork for just the reasons we've looked at. But you haven't so far suggested there's any substantive content to authorisation other than non-expulsion, so to speak.
Well,
is that right?
So far I have not, and that's because I've split my argument into two. One is that the narrower argument that some form of formal documentation is required, and that's the point I'm making now. But what I'm going to go on to say, and these submissions apply to Article 13.1 in as much as they do to 10.2, relates to the substantive content.
Thank you.
So I mean, I'm at the end of my submission on the first issue. We say, and we would invite the court to find, that the Secretary of State's current policy framework fails to give effect to the obligation in Article 13.1 to formally authorise a victim's stay.
I mean, can I just ask you why Article 13.1 last sentence is not referring back to the penultimate sentence because it says during the period, which is in the middle, in the sentence in the middle says during this period it should not be possible to enforce any expulsion order. That's obviously referring to the recovery and reflection period. Then it says, this is without prejudice to the activities carried out by competent authorities in all phases of the relevant national proceedings, and in particular, when investigating and prosecuting offences concerned. During that period, this period, the parties shall authorise. So it looks as if it's talking about maybe a coterminous period, but a period in which the period of relevant national proceedings when investigating and prosecuting offences. It looks like it's a special requirement for that.
We say it's not. Article 13.1 contains, Article 13 as a whole contains, I think it's four references to during this period. And it's paragraph 178 of the explanatory report that makes clear that that final reference in 13.1 to during this period refers to the recovery and reflection period, because paragraph 178 of the explanatory report says each party shall provide victims with the relevant documentations authorising them to remain on its territory during the recovery and reflection period. It doesn't say during another period. It refers in terms to the recovery and reflection period. It's at page 622.
Yeah, now I've got it. Okay, thank you.
Unless there are any other questions on that, I'll move on to my second submission. That is, in order to comply with the obligations under Articles 10, 12 and 13 of ECAT, in at least some circumstances, the Secretary of State will need to grant a form of temporary leave. But the current policy framework does not permit this. So again, I'll develop this point sequentially under three broad headings. First, I want to briefly, because I know this has been covered, but I want to briefly make a few points about the hostile environment measures. We say that victims without leave are exposed to the hostile environment, which is prejudicial to their recovery, which disincentivizes them from participating in the NRM process or with the investigation of and prosecution of their traffickers, and that it exposes them to the risk of further exploitation or re-trafficking. Now, the purpose of the hostile environment policy, as set out in the Windrush Lessons Learned Review, it stated that it was to make life as difficult as possible for people with no legal status in the UK, to encourage them to leave. And we know that the Windrush generation were unintentionally affected by the hostile environment, and we say so too are victims of trafficking. And we've set out in some detail the precise effects of the hostile environment as they apply to victims of trafficking in our written submissions at paragraphs 26 to 30. The Skeletons bundle, page 97 to 103. I'm not going to repeat those, but I do want to clarify just a couple of points that were made yesterday regarding criminalisation. It's a criminal offence to enter without leave, to overstay, or to breach immigration bail conditions. And there was some question yesterday as to whether victims of trafficking may have a defence under Section 45 of the Modern Slavery Act. Under that provision, victims would need to show that they're compelled to overstay as a direct consequence of being a victim, and that a reasonable person would have no realistic alternative. And all that we say about that is that it's not straightforward to make out that defence. In particular, as the Secretary of State is arguing in these proceedings that there are various routes by which potential victims can apply to extend their leave.
Well, yes, in cases where that was so, there might be some who've never had any leave at all, that has been smuggled in.
Well, we have arguments to make about why there is no practical and effective route. But the point I'm simply trying to make is that whilst there is a defence, it's not necessarily a straightforward one, and it's certainly not going to, the existence of defence isn't going to protect victims from the possibility of arrest, detention and prosecution. And even if that risk is a minimal one, it's important to emphasise the impact of a perceived risk on victims and the adverse psychological impact of that. We set out in detail in our submissions the restrictions on victims' autonomy, their access to services, the fact that they're required to survive on subsistence level benefits. I won't repeat that, but there are specific provisions that impact on victims of trafficking differently to others. For example, victims of trafficking with children, insofar as they're able to, or restricts their ability to access childcare in a way that doesn't affect asylum seekers, for example, or the requirement for them to pay for their children's secondary health care. Again, that's not a requirement for asylum seekers. So I'd invite the court to look at our written submission, but I won't say anything more about that now. One point I do want to highlight is that there is a very real problem of victims going missing in the UK.
Sorry,
There is a,
competing with an aeroplane.
I'll repeat that. There's a very real problem of victims of trafficking going missing in the UK. Our submissions at paragraph 32, footnote 33, explain that the available data shows that between 2014 and 2019, 784 cases were suspended. Now, it's the Secretary of State's policy to suspend a decision on whether a person is conclusively found to be a victim of trafficking, where they go missing and they don't have sufficient evidence to make that decision. We haven't included that in the bundle, it's hyperlinked. I have copies of the table. If the court is interested in, we can hand them up and email them to the court if the court's interested in looking at it.
Well, you can send it.
Would the court like paper copies in addition?
On paper for me, thank you.
Well, if my lord said to have it electronically, we may as well have it on paper, but give it to us at some lunchtime.
How are we doing for time, Miss Christie? I think you've had your half an hour.
I think I have. The next point I was going to make is the substantive point about the content of the obligations under 10, 12 and 13. I don't envisage I'll take very long with it, but I do hope that it will be of some assistance to the court, because we have a few points to add to those that have been made.
Right. I mean, what I'm concerned about is we really must finish this case today now. Should we work backwards for a moment? Mr. Tam, how long's your reply going to be?
Lord, realistically, probably an hour, or maybe a little bit more than an hour. I'm not in the habit of repeating things that I've said in opening, so I will try to be as efficient as I can.
You'll find that a very attractive attitude from the court's point of view. Ms. Weston, you've got an application to make to amend your respondent's notice. I'm utterly confused as to which version of the thing I'm supposed to be looking at, but at some point somebody will show me the definitive one. How long is that going to take?
Subject to questions of the court, I wouldn't have thought more than about 15 minutes.
Right, I think that's right. And Mr. Tam, you'll have to reply to that, and you might take 15 minutes to...
I might, one of the consequences of the way that it was delivered to us is that we are awaiting instructions on our stance to that. But if I'm going to oppose the application, then probably 15-ish minutes.
Okay, well, I think, Ms. Christie, we'll adjourn now and resume at 2, and I'm going to give you 15 minutes, but I really mean 15 minutes. All right?
I'm grateful, my lord. I don't anticipate it will take any longer than 15 minutes to deal with
We've
this
been
case.
relatively good for this panel of the Court of Appeal in not interrupting you, and we'll try and do even better at 2 o'clock.